Ladies and gentlemen, welcome to session 2 at Data Protection Summit 2022. Thank you for tuning in. Our next session is with Laura Irvine. Delighted to have Laura join us remotely today, which we're still getting used to in the current climate, but delighted to have Laura with us. Laura, I'm going to hand over to you. And at the end of the session, if anyone does want to ask any questions, please just type them in the comments box and I will relay them to Laura at the end of the session. Over to you, Laura.
Excellent. Thank you very much. And welcome everyone in the virtual world. I was announced earlier as having a COVID diversion by Mark, who I think was shielding the information, the special category data information about me actually isolating because I tested positive at the weekend. But as you can see, ladies and gentlemen, I am fine and just really disappointed not to have been at the conference in person, but then it allows me to speak to you in this virtual world instead. Sadly, cannot see people's faces and people's reactions, which is something that I've very much missed for the last 2 years in this virtual online webinar society that we have been living in. I was looking forward to getting back to being in person again, but not to be. Next week I'm going down to Leamington Spa, ladies and gentlemen, to actually do a similar presentation down there to a group of data protection specialists. So I am looking forward to that. And of course, by then I will be bulletproof because I will have all the antibodies and nobody can get to me again. So looking forward to that. But anyway, let me go through what I wanted to talk to you about today. And it's something that I've been mulling over for a while. And as a data protection lawyer, issues about regulatory action, but also compensation claims keep me occupied on a day-to-day basis, shall we say. And one of the issues that I'm quite passionate about is to look at both regulatory action and compensation claims as a tool to encourage organisations to approach data protection laws in a different way. And what I want to talk about today is perhaps issues that haven't hit the headlines as much as security issues in terms of data protection compliance. And I'm going to talk about more of the other types of issues where regulatory action has been taken, but perhaps not in such a high-profile way, certainly in the UK. But also I want to talk about data breach, I suppose, compensation claims that we are seeing on the increase, some of which I think are interesting and could assist in terms of compliance, and others which are perhaps not as significant and are being brought by some might say lawyers who perhaps don't understand the nuances of data protection law, and hence my title was "Help! There's been a data breach," and actually sometimes there hasn't, or certainly there's not something that deserves a compensation claim to be awarded against that individual or the data controller. So let us move on to the first slide. And I can't move my slides on. Don't know why. I can't move the slides. Okay. I can see, I can, oh yeah, here we are, there we go. There's the first slide, ladies and gentlemen, and it's a bit of an anticlimax after that wait. I am not going to talk about the big fines. So we've all seen these hit the headlines, and we've probably all been at many talks in relation to these big fines, and we know quite a lot about what happened. And certain of these fines, the Ticketmaster one in particular, I know is being appealed. I'm not sure about the other two. I think they've been paid. But we've discussed these enough. What I want to talk about is other types of enforcement action, and this particular decision from the ICO caught my attention. It was issued, I think, at the end of it was just issued very, very recently. So this deals with the issues surrounding the Scottish COVID passport app, which was introduced at the end of September last year, and obviously came alongside the requirement for us to demonstrate our vaccination status at particular venues and also in relation to international travel. So the ICO was obviously very interested in all of the activity around, I think in particular, technology that was used to deal with particular issues during the pandemic. And certainly the passport app was introduced in Scotland and it was obviously looked at very carefully by the ICO. And what came out just earlier this month was not a fine from the ICO, but a decision notice to reprimand the Scottish Government and NHS Scotland in relation to some of the issues of concern in relation to the app. So I thought it was worth talking about those, because it's not headline big data breach, security breach issue, but there are some really good learning points that I think we can all use as data protection practitioners to learn from. So one of the initial issues of concern was that when the ICO was made aware of the proposal in detail to have a passport app in Scotland, this was very shortly before it was due to launch. The proposal was that the facial recognition technology that was being built into the app, which was run by a third party, that the app would allow that third party to hold on to the photographs, the facial recognition still photographs for an additional 5 days after the initial identification verification was carried out, to allow that third party to develop its own technology in terms of facial recognition. So the third party obviously would become the data controller, and that would be special category biometric data. And the ICO was very concerned about that. And indeed, the Scottish Government and NHS Scotland did not go ahead with that part of the proposal, and so that did not happen. However, I think that it perhaps led to an awful lot of changes being made to the privacy information that was then delivered alongside the passport app. And that has led to some concerns that the ICO raised in this decision notice and the reprimand that they issued against both the Scottish Government and NHS Scotland. So some of these issues were really about telling people what was happening to their personal data within this app. And that is something that I have been looking at quite carefully over the last few years, and trying to work out, what's the best way to tell people what's happening to their personal data, particularly in an online and digital setting. And I was able to listen into the plenary session this morning, and clearly there was a lot of discussion, particularly in the Q&A session at the end, about how difficult that is to understand, and particularly in the world of cookies and online advertising and ad tech. But in this case, I think it was so fundamentally important that information was provided in a clear and transparent way, as is required, as we know, by the GDPR. And the ICO were critical of the clarity of that information. They were critical of the accessibility of the information. And initially, it was very difficult to find the privacy notice in relation to the app. And the information within that privacy notice was combined with information about other service provision in relation to various other aspects of COVID, including the paper form of the passport, etc. So that information was not provided clearly, and the ICO were very critical of that and continue to be, actually, and they've requested an updated privacy notice to be provided by the end of this month. So feel free to go on and have a look. And indeed, there were several examples of privacy information being provided by the government, by NHS Scotland, NHS Inform in particular, throughout the pandemic, which was trying to explain what was happening to our personal data. Track and trace was a good example, I think, of where that information was provided. But what became very confusing, I think, in this case, was the information sharing. And often I find that that's something that people get very upset about, the idea that their information, their personal data is being shared, and quite right. So, however, we all as data protection practitioners appreciate there's a difference between sharing with another data controller, sharing with a data processor. And in general, a lot of the concerns that were raised, and there were media articles and MSPs commenting on this data sharing, that data sharing was with a data processor, and therefore Amazon wasn't using our COVID status on its own account, but it was simply storing some of that information on behalf of the government. And that is easy for us perhaps to understand as data protection practitioners. And I say that with the understanding that sometimes it's very, very difficult to identify processors and controllers. But in the context of privacy notices, in the context of the transparency information that we are having to advise on or providing to our data subjects, we need to get better at that. And that's something that I'm really passionate about. I received an email from out of the blue, from someone who was very concerned about the Scottish Government sharing COVID details with Amazon and with I think it was the Royal Mail was the other one that was cited. And obviously, there were concerns that were raised by the ICO in advance about the information being shared with Jumio, but that didn't happen in the end. So I don't know if these concerns stemmed from that initial intention. But anyway, I think that was very interesting to look at the privacy information, and perhaps we should all be looking at it with more of a critical eye and working out how we can get better at that and how we can get better at giving that information. And I think that becomes much more important at an individual level, and particularly when we start, and I will talk about this later, when we start talking about compensation claims. It's one of the issues that I quite often will raise with people who are coming to me in terms of a data breach. Yes, there may have been a security breach, but actually what else is going on in the background, and the transparency obligation is very often not complied with in these circumstances, which causes a lot more concern and upset than it needs to. I also thought it was worth looking a wee bit at what other regulators are doing, those in the EU. This has given me the opportunity to produce some flags, and we could have a quiz if I was there in person, but rather more difficult online. So other EU regulators are perhaps imposing fines or taking regulatory action in relation to other issues. So when you look at the fines that the ICO has imposed under the GDPR, they have all related to security breaches, and other aspects of data processing may be picked up within some of the decision notices, but the headline is it's a security breach, and not entirely, but often, and the first slide demonstrated that there are significant fines imposed on large organizations. And again, something that I've been mulling over and that I've been interested in is the regulatory action taken at a lower level, and in relation to many of the other fundamental aspects of data protection law that we talk about on a day-to-day basis, and that we are probably passionate about, and that needs to be reinforced for data controllers and for organizations processing personal data. And I think that looking at some of the enforcement activity that's been taken in the EU can assist in relation to that. So I had a look at some of the fines. Yes, people, I've been bored and stuck inside, so I've had plenty of time to do this. And I came across a fine that Iceland had imposed, and this was at a low level. of fine. It was 7,000 euros, sorry, imposed on a venue pre-COVID, and that fine related to that venue having collected information when it was selling tickets for a performance, but they were collecting social security numbers and they were collecting the date of birth of these individuals. So there was no reason for that information being collected, and we can all see all of the data protection principles that would have been breached in relation to the collection of that data, and the regulator in Iceland fined that organisation, highlighting that personal data should only be collected and used when it is absolutely necessary, highlighting the data minimisation principle, the purpose principle as well. So that I thought was a low-level fine, but a really good way to educate people in terms of thinking about what data they're collecting. The second flag, ladies and gentlemen, is Romania. And again, the Romanian regulator has imposed several fines in a different area, so in relation to data subject rights. And I was interested to look at some of these decisions. I can't do that in detail because they were obviously in a different language, and Romanian is not one of my foreign languages. But they were certainly, it was certainly clear that the fines were imposed in relation to the failure to provide information in response to a subject access request. And it wasn't about not providing a response at all, but it wasn't providing that list of additional information that's required by Article 15. And again, these fines were of a low level, 2,000 or 3,000 euros each. But again, they highlighted an issue. And I expect that you will all have come across concerns and issues about data subject access requests. And I know that the ICO receives, I think the majority actually of its complaints are about subject access requests and the failure to comply with them. So again, it's an issue that's highlighted, and it's perhaps a tool for us to be using as data protection officers in the main to demonstrate how important it is to comply with the obligations under Article 15. And then finally, the last flag on the slide is Spain. And Spain, if you look at the lists of fines that have been imposed under the GDPR, it's the most prolific regulator, and it has imposed the highest number of fines. And some of those have been at a significant level, but lots at lower level. And again, with that general data protection principle compliance at the heart of them. So there were fines issued in Spain for the failure to comply with the transparency principle, and also Article 13, so not providing information in the way that it should be. And also, interestingly, fines for failing to cooperate with the regulator. And again, lots of low-level fines, but highlighting these issues beyond security issues that the GDPR tells us we have to be very aware of. And it strikes me that a lot of these issues, for me, are really fundamental in terms of public trust. And I listened to the DCMS presentation and obviously have read the consultation and drafted the response for the Law Society Privacy Committee, which I chair now. And that public trust piece, I think, will become much more important as time progresses, as people get more aware of their rights, as more information is online. And the last 2 years throughout the pandemic, I think, have demonstrated that people are more aware and people are more interested and more concerned about what's happening. And I would like to think that any changes that do happen are taking into account the need to make sure that public trust continues, because if it diminishes, then the aims of the DCMS to make sure that we are using data effectively and to the public benefit will diminish if that trust is diminished. So the other thing I'm not going to talk about are these massive civil claims. We all got I think in this world, we all got very excited about the Morrison's decision in the Supreme Court, which came out, of course, just less than a couple of years ago, basically at the start of the first lockdown, and was unsuccessful. But a group action that we all have to be aware of as data protection practitioners, and the possibility of something similar happening again is very important. The Lloyd and Google case is still rumbling on, albeit it was unsuccessful in terms of the compensation claim, which didn't relate to distress or damages, but related to that loss of control element. But I suspect there will be other activity in that area as well. And just Equifax at the moment, that there was a security breach there, and there is a class action, a group action, which is being debated, or was being debated this week in English courts. That had been a representative action, which was similar to Lloyd and Google, where it wasn't clear what the damages were, and it was an opt-out as opposed to opt-in litigation piece. Anyway, it's now become a group action. People have to opt into it. These are the big organisations and headline-hitting claims. But let's talk about some of these other low-level claims that perhaps don't hit the national headlines in the way that these ones do. But again, I think they're useful. Some of them are useful tools for us as data protection practitioners. And also, I'm going to refer to a couple at the end, which are useful to see where the courts have said, actually, we don't think there is a big issue here, and we must also keep that in mind so that there's been a data breach piece is kept under control. So I forgot to say at the beginning, I've decided that I'm just using pictures in all of these slides today and very few words. So I found all these little icons to demonstrate the cases that I wanted to talk about. So this first one was an employee of Tesco's. So supermarket, hence the trolley, and her during I think there was an employment dispute, and during that employment dispute she asked for a copy of her HR file. That HR file contained 15 years worth of information about her and about some very sensitive issues in relation to medical conditions and mental health conditions and postnatal depression that she'd suffered. And I understand that there was a lot of information within the file about those issues. That file could not be found by Tesco's. They simply lost the file. They did not know where it was. And the lady was awarded compensation, not by a court. There was an agreement out of court of £3,000 for the loss of that HR file. I have personally been dealing with a couple of claims and a couple involving HR files, and I think it's as we know, they often contain a lot of sensitive data, and every employer has these files, and they generally are looked after very carefully by an HR team, but mistakes can happen. And one of the issues of concern that I have and that I am dealing with are sometimes information that's not held within the official HR file, but perhaps could be described as an unofficial HR file being held by perhaps a line manager, and not only will there be potential security issues with that, but also all of the other data processing principles will kick in there in terms of what's the purpose of that, accuracy, making sure that file has a good reason for existing and that it's used for the correct purpose. So HR files, I think, are difficult, and we know that as data protection practitioners, and they're also a focus, I suppose, for compensation claims, particularly when an individual is in dispute with an organisation. And I think that leads me quite nicely onto the next slide in this case that I wanted to refer to. So this again involved an HR file an individual employee was in dispute with its employer and asked for a copy of the file. That file was emailed to someone in the organisation, but not the individual employee that had requested it, but someone who had a similar name to him. So he raised a claim for a data breach in the courts, and although on the face of it, when the employer put in its defences to this claim and tried to get it kicked out of court, what the data subject found out at that stage, and this was 14 months after he'd been told that his HR file had been emailed to the wrong person. It was only at that stage he found out that the individual who'd received the email by mistake had not read it and had deleted it immediately. And so the lesson, I think, from this case is very much that communication piece. You've had a data breach. This is a security issue. However, you have an obligation to tell the individual, and clearly that had been communicated to the individual. But that communication did not continue, and that reassurance could have been provided on the same day or very shortly thereafter. It was established that the individual hadn't read it and had deleted it. But the data subject didn't find that out until 14 months later, and clearly the distress levels are greater because of that loss of control, and they thought that someone else who works in the same organisation has a copy of his HR file. So these are the kind of low-level cases that I wanted to just talk about in terms of claims, and to think about the issues that go along and with that, the kind of, I suppose, the learning issues that come from these cases, and particularly that second case. Communication with the data subject when something goes wrong is very important. I also want to talk about these two next cases, which are the de minimis principle being applied, and this is in English courts. And this is where actions have been raised, and the court has been very critical, actually, of the lawyers involved, but also critical of the fact that they've been raised in a high court where there's a higher level of damages, or an expectation of higher level of damages. And they have been not flung out exactly, but the courts have been very clear that they shouldn't be raised in this way, and that the damages that the individuals can expect are a very, very low level. And if they reach the de minimis level, which is an English law concept, where you can understand what it means if they're so low in terms of damages, that they should not be in court at all. Therefore, they're not really a compensation claim, a valid compensation claim under data protection legislation. So the first one, Rolfe against Wasborough Wizards, involved a bill for school fees. That was sent to the wrong person, a randomly wrong person, a mistake with the email address. And the individual here raised a data breach claim in the High Court. Damages are pretty significant. I think the threshold is £100,000, and this was a breach involving very minimal personal data and sent to a random person who was not connected with the individual. There was no bank details contained within the document. It was simply contact details and the information about the fees that were owed. And actually, the judge was very critical in this case, and although he allowed the matter to proceed, he transferred it to the lower court to decide on the merits of the appeal. So a very preliminary decision in this case, and they haven't looked into whether or not there was actual distress. But the judge was very sceptical about the distress that could possibly be caused by something as minimal as this. And I think this is a good case to think about when you're dealing with data breaches, and commonly the data breaches at this low level are emails being sent to the wrong person. What is the likelihood of damage, and what level of damage could take place? And hopefully sometimes that will be reassuring and sometimes it won't, depending on the context. I think one of the issues that's significant here is that it wasn't sent to someone within the same organisation as we were dealing with in the previous case, but it was someone external or not connected really to the data subject who raised the concerns. Similarly, the next case concerned housing association, and an individual asked for a copy of their rent statement to be emailed to them, and the housing association by mistake emailed a document which contained the rent statements of many individuals. It was a very large document, sort of almost 7,000 pages of information. So lots of information being sent to the wrong person, but it was a rent statement. It was the amount of money that was due. And in this case, one of the individuals whose information had been contained within that document raised a claim in the court, and again it was raised in the High Court, so seeking significant amount of damages. And there was various heads of claim raised, including a suggestion that the information within the document would become known to a former partner of hers. And the judge was sceptical about that. And it's not that that isn't a possibility, but was it likely in these circumstances? And that was that led to the judge again being critical of the place that the action had been raised, and also doubting whether or not anything other than a very modest claim could come from the information that had been disclosed to the wrong person here. So again, an example where the de minimis principle was looked at and was explored, and where the court said they were sceptical and critical of the claim being raised at all. And that leads me to the last slide here, which I feel is a little bit like torture, because it's almost lunchtime and I've got a picture of cookies in front of you. And I know that cookies have been talked about today quite a lot in the first plenary session. And let's face it, it's a very small part of the job that we do as data protection practitioners, but it's something that has caught my attention for a particular reason. And that is to do with claims for compensation being made by individuals against data controllers who are running websites where cookies are being deployed without their consent, allowing personal data to be shared with third parties generally, or data that can be personal data in the hands of third parties. And also there is concern that some of these third parties will be transferring that data to the United States, and on the back of Schrems 2, that is obviously also a concern. And we've seen regulatory action in the EU in relation to that issue. So I just wanted to finish here because I found these kind of compensation claims letters to be of interest to me in terms of the advice that I was providing to clients. So I would often talk about cookie compliance, PECR compliance, obviously, and how that had changed sort of when the GDPR was introduced. We all know that it had been the consent requirements had been watered down considerably. GDPR brought in a much more stringent standard for obtaining valid consent. There was a space where certainly the guidance didn't quite reflect that. And then it was, I think it was summer of 2019 that the ICO changed their guidance. CNIL in France changed their guidance. And certainly since then, there has been a focus on the requirement for consent as being much more than clicking an accept or a cookie notice at the bottom of a website. So lots of activity there. And it was a difficult one. It was a difficult piece of advice to sell to clients. So I would be saying this is what the law says and you need to be compliant with it. And the question would be, or what? And in this country and in the UK, the ICO wasn't or hasn't taken any action in relation to cookie compliance since it changed its guidance in 2019. And then these claim letters started coming through. And actually, I've found them a useful tool in terms of encouraging that compliance piece with my clients. And although they are I'm slightly uncomfortable with that tool being used and effectively using court action as a kind of a very difficult incentive, particularly for smaller organisations, to change their practices. It's really important that they do, and I am. Unlike I think one of the questioners this morning, I am still very concerned about the loss of control online and the use of ad tech in relation to my data. And I do feel that something needs to be done. So the first step, low-level claims for compensation in relation to cookies. And it's not to say that I think that is the best use of compensation claims, but it was an interesting model that allowed me to provide stronger, I suppose, advice in relation to compliance, because there could and there was a real prospect of the company being subject to these compensation claims, and not even just a financial issue, but also a reputational issue that the organisations and my clients were very conscious of, and which resulted in change in a way that I hadn't been able to encourage perhaps before. So that's kind of the end of what I wanted to say today, and it's just some thinking I think that I'm developing in terms of compensation claims and in terms of regulatory action. And very important, I think, for us to use the messages from all of these types of cases and look at the European regulators and what they are doing in this sphere. We have a new information commissioner who's already been discussed today, and I'm looking forward to hearing our ICO representatives speaking this afternoon as well. And then maybe there is an opportunity for that lower level of enforcement action to take place, to emphasise and bring to the fore all of the issues that we are all passionate about as data protection practitioners, but in a really good, positive way, so that we can encourage compliance. And it is a little bit of a stick rather than a carrot, but it is useful in certain contexts to have that stick in your back pocket. So that's my presentation for today. Thank you all for listening in, although I can't see, maybe there was nobody there, but hopefully you did, and I really do hope to see a lot of you in person in the not too far off future. Thank you.
Thank you, Laura. We honestly have been sitting here captivated for the last half an hour talking amongst ourselves about about everything that was raised, having a little mini debate here in the conference centre. We do have a couple of questions that have come in, which I'm disappointed about because I have so many to throw at you myself, but we'll save that for another time. We've got a question from Vicky Ambrose. She says, "Hi Laura, regarding the individual whose HR file had been inadvertently sent to the wrong individual, while 14 months later it was determined that the file had not been opened, as you say, the individual may have been significantly upset over the 14-month period. Could they have sought compensation for the stress and distress caused, even though the data had not been viewed?"
Yes, oh, absolutely. I think that is a valid head of claim, because it's not a lot of the thinking about distress as the potential for distress. And if you think about the Tesco case, where the file's just simply been lost, now that could have been shredded inadvertently, but the individual doesn't know, and they don't have the reassurance. So it is a loss of control argument, but a loss of control coupled with the fact that the information contained in that file. Certainly in the Tesco case, I don't know about the other case, what was in the file, if it was as sensitive. But yeah, I do think that is a head of claim, put my lawyer hat on, that would certainly be, that would increase any claim for compensation. And it's such an easy thing for an employer to do, to communicate its investigation to its employees. And it's something that I am dealing with in a live case at the moment as well.
Yeah, and like you say, I think it's the end result of it is the distress caused, regardless of what the action that's been taken behind the scenes. With the civil cases, I mean, obviously 4 years now since GDPR came into force. What's the kind of trend in the civil cases that you've seen? You obviously throughout your presentation have said we need to get better, we need to get better. And as you've said again, I think for a lot of companies that's stick rather than carrot sort of situation for them. But how have you seen the civil kind of thing? Have you seen an increase in cases, or have you seen it go down?
So there's definitely been an increase, and there's kind of, I suppose, what I was trying to put across in that presentation. There's been big group action claims, so Morrison's and the Lloyd and Google claim, and then Equifax, and there's BA settled their civil claim. Ticketmaster has a civil claim which has been assisted or stayed, as they say in England, until the fine appeal is going through. But these are kind of what's difficult in a data breach situation is that the level of damages isn't terribly high, and these are new types of claims. So in a personal injury context, there are lawyers and legal firms that are set up and very responsibly set up to deal with people who don't have the money to fund a claim and who would be very nervous about the suggestion that they might have to pay thousands of pounds. So you've got these kind of no win, no fee situations. The world of data protection claims hasn't quite got to that level yet. And as I was trying to as well say, there are some people who just don't get it. They don't understand what a data breach claim, compensation claim is. But that will increase, and there are responsible lawyers out there taking these claims as well for proper basis. I like to think I'm one of those, and I have several at the moment, which I'm really passionate about organisations learning lessons and getting it right. So there's two different types of claims, and some of these big claims, of course, are funded by litigation funders, and that's a whole other world of discussion, and that's attractive to them because they will win a percentage of the claims that are there. But actually the really important thing is this learning from mistakes from the lower level of claims when they're taken properly and when the proper grounds are raised in terms of compensation. Yeah,
and and ultimately that's what we hope to come from any case in that situation. And I think with civil cases, for something else, like you said, if it was an injury claim, for example, the civil route for it would obviously be, going to court and judge determining compensation payout. With the data protection side of things, with data breach, how does it work legally in the sense of, I can understand the compensation piece, but for the company who are the defendant effectively in that situation, is it that the judge can hand out a certain fine, or is it they're kind of referred to the ICO? I mean, how does that relationship work?
Yeah, the two are separate. So the judge in a civil claim will hand out compensation under the GDPR, and there can be claims for misuse of personal data and breaches of privacy under the Human Rights Act and various heads of claim, but that's compensation for that individual. The ICO takes separate regulatory action if it thinks that it should, and that's where the company is fined. So it's called a civil monetary penalty, but none of that fine goes to the individuals who've been affected by the breach. Yeah. So the two processes are very separate. And there were discussions when the GDPR was coming in about whether or not some of the fine money should go to individuals in terms of compensation. That's a very big kind of discussion and fraught with difficulty. But is something that shouldn't be dismissed and that perhaps should be talked about. But the two things are separate, and the level of compensation is an area which really needs to be looked at, and you know, the more cases that come through, the better understanding we will have of that. But I spend quite a lot of time thinking about what is the right level of compensation, and that for personal injury claims, believe it or not, there's a book that tells you how much a broken leg's worth, and you know, that doesn't exist for protection claims.
Yeah, and you know, at 4 years on, we are still learning and still working through that process, as you say. But we've managed to turn our half-hour session to a 45-minute session, and I would not have had it any other way, Laura. Oh. So, honestly, Ray and I will be knocking at your door once you're safe to do so, and I will
once I can come out, yes.
Yeah. But for now, thank you so much, Laura. Laura Irvine from Davidson, Chalmers, Stewart. The Davidson, Chalmers, Stewart team, for anyone who is at our physical event today, you can chat to them upstairs. Any other questions you've got for Laura, you can message me on the platform, and I'm happy to relay her post talk as well. For now, Laura, thank you so much for being part of the event. Good to see you as always, and we look forward to seeing you again in the near future.
Excellent. Thank you very much.
Thanks, everyone.